Hi, welcome to HR Insights with SN.
I would like to ask this question. So what is the fate of an employer whose employee terminates a contract without following the due process?
Now, to answer your question, let me say the law is not discriminatory. All the things that we've been saying that applies to employee also applies to employer, in the sense that if the employee decides to terminate in breach, that is exactly the way I'm going to couch it. Now, employer has the option of also instituting action against the employee. The issue is just, the practice is just, we don't really see instances whereby employer decides to sue the employee, except if the contract is a contract in which the consideration is very much, the wages are very much, and we usually see that in the aviation industry. Other than that, you seldom see instances whereby employer files an action against the employee. But why not? Why can't an employer file an action against the employee if the employee resigns in breach? Of course, the employer can do so. Now, another thing the employer can also do is with respect to reference. With respect to reference. Because if the employee decides to terminate in breach, and unfortunately for that an employee, if reference comes, of course, the employer is not under an obligation to reference for that particular purpose. So those are things that the employer needs to know, that will make the employee to believe that they can't just do and undo. But again, one thing I will say briefly, although not associated with your question, is that there is something that employers normally do. They will engage someone, give the person offer, allow the person to accept, and they will not call the person to resume. That is very, very wrong. That is called legitimate expectation, and that is extremely wrong. I think if I can have opportunity to further expatiate on this, we will see the implication of this, but I know that is now very common in the industry.
What's the position of the law on non-compete clause, where an employee is not expected to work with a competitor for a certain period of time?
Now, to answer your question, let me start from the issue of dismissal. I think it is very instructive to say that the position now is that whether an employee is terminated or dismissed, the employee is entitled to benefit. That is the position now at the level of the National Industrial Court. And the logical reasoning for this position, or the logical basis for this position, is that we need to agree that the benefit that an employee is entitled to, he would have been entitled to that benefit before the commission of that dismissible offense. So for us to now say that because of dismissal, an employee is not entitled to a benefit that the employee would have been entitled to if the employee has tendered the resignation letter before that dismissible conduct is committed, is very, very unfair. So the position now is that whether dismissal or termination, benefit to be paid. Now, as far as notice is concerned, the provision of notice is regulated by Section 11 of the Labour Act. Just for me to quote that provision directly, because I saw that you made reference to if the contract of employment is 5 years or more. Now, the position is that Section 11, subsection 1, where a contract of employment is less than 3 months, 1 day. Where a contract of employment is 3 months but less than 2 years, 2 weeks. Where a contract of employment is 2 years but less than 5 years, that's 3 weeks. And where the contract of employment is beyond 5 years, that's 1 month. Now, having said that, we now need to understand the fact that that particular provision will not suffice in a situation where the contract of employment has already stated the amount of notice that parties will give. So if the contract of employment is totally clear on the notice period, then it is the notice period that will suffice in that situation. Now, as far as the 3-month notice is concerned, if that is what is contained in the contract of employment, then that is what will regulate the parties. And that is the case because of the principle of consensus addendum and pacta sunt servanda. Now, consensus addendum means meeting of mind. Pacta sunt servanda means a promise once made is absolutely binding. So if a contract of employment is executed, that contract of employment is blanketed by the provisions of Pacta Sunt Servanda, which is a promise. Now, having said that, let me go to the non-competition clauses. Now, the non-competing clause is a shred of contract in restraint of trade. And there are three principles that regulate it. Number one, the first one is the year or the length that the contract is supposed to take, that is the duration. In essence, if the contract, the non-competition contract, if it is more than 3 years or more, it is contrary to public policy. That's the general position of the law. Number two is your function in that particular company. For example, if you enter a non-competing clause and your function is, let's say, general manager, and you want to work in a separate employment that doesn't pertain to your function, it will not cover. Are you getting it? And again, is the geographical location, of that particular employer. For example, if the non-competition clauses cover a geographical location within Nigeria, and you want to go and work in, let's say, Scotland, or you even want to work in Ghana, and the non-competition clause does not restrict you from not working in a West African country, so it will not regulate. So we need to, but again, we need to understand the fact that generally, non-competition clauses are seen to be contrary to public policy. That's the case of Kumulis against Leventis Motors. They are seen to be contrary to public policy because they restrain your freedom of association as contained in Chapter 4, Section 40 of the 1999 Constitution. You have the right to compete. And the employer also that is giving you that non-competition clause has the right to improve his services. So if the employer improves his services, then that non-competition clause will not be binding on you again. So the non-competition clause is not generally enforceable. It is enforceable with restricted conditions.
Given your experience, your worth of experience, obviously, and your knowledge in law, if you have the opportunity to change anything in the HR space, what would that be?
Well, the basic thing I want to change is a situation where all classes of employees will be equal. And I need to say this. I really detest contract staff, engaging someone as a contract staff and making the employment of that person subordinate to his other colleagues. Now, the reason I'm saying this is nothing less than because of the Discrimination Convention, that's Convention 111. And even Section 42 of the 1999 Constitution is very simple. Nobody must be discriminated against, even on the basis of sex, on the basis of race, and even to that extent, even on the basis of employment. Why must you engage someone as a contract staff, be paying that person 50,000 naira, and you engage the other person as a full staff, and you're now paying that person 500,000? And the person that is being engaged as a contract staff is doing more than the person that you engage as a full staff and you're paying that person 500,000. Is that fair? It's not fair, it's not reasonable, it's not logical. In every sense of it, that should not be. So that is the basic thing I think one needs to change in the labor space. Every employee must be equal. Every employee must, they must operate on the same level. In fact, there is even a convention on equal remuneration and equal pay. That's actually Convention 138, equal remuneration and equal pay. So to that extent, that is the basic thing I think should be changed, in the labor space. No contract staff. Everybody must be paid equally. Everybody must be subjected to the same employee welfare, to the same social welfare scheme, pension, employee compensation, and all other welfare schemes, social welfare schemes for the employee.
Thank you so much. This has been an electrifying conversation, and I believe it was insightful for you as well. Thank you, and stay tuned till next time. From our headline sponsors, partners, and producer, we say a very big thank you for staying tuned. Please join us again. Bye for now.